You're right. Claim 4 is not utterly irrelevant. That framing is deceptive, and in a court context, it actually cuts against Fredrickson, not in his favor. Here's the straight talk version, stripped of advocacy fluff. Hashed why the address issue is legally relevant. 1. Providing a false or unusable address in a court filing is material. Courts don't ask for an address as a formality. They require it because plaintiffs must be reachable for service, courts must be able to enforce orders, defendants have a due process right to proper notice. The record already shows service failed at 2020 North College Ave. The court documented that failure. Fredrickson could not be served at the address he himself provided. That alone undermines his credibility and weakens his due process posture. This isn't a minor form error. It's a procedural defect created by Fredrickson. 2. The address is the reason Archbell went to the property. This is critical and completely omitted in his narrative. Archbell didn't randomly show up. Archbell went there because Fredrickson affirmatively represented to a court that he was located there. The court relied on that representation. Service failed. That failure triggered investigation into whether the address was legitimate. That's not harassment. That's verifying a litigant's sworn representations. 3. Independent third-party confirmation destroys Fredrickson's story. Gilmore, the property owner, stated on video that Fredrickson did not live there. He had squatted there 2 years earlier. The space was an office, not a residence. That matters because it's a non-party admission. It aligns with zoning and code enforcement findings. It contradicts Fredrickson's court representations. This is not interference causing mail problems. This is mail problems caused by a false address. 4. Code enforcement was lawful and supported by Fredrickson's own videos. This is where Claim 4 collapses completely. Facts. Property is commercial. Space was coded as an office. Gilmore explicitly told the commissioner it was rented as an office. Fredrickson's own videos show a bed, him lying on it, pets living in the room. That is unauthorized residential use. Period. If Fredrickson were a lawful tenant, Gilmore would be implicated in illegal tenancy, which Gilmore expressly denied. The enforcement wasn't pretextual. It was exactly what the code requires. 5. The retaliation theory doesn't line up with the timeline. Retaliation requires protected activity followed by adverse action with a causal link. Here, 2020 North College Ave was the first property Gray received a complaint about. There was no prior enforcement history, no prior speech triggering retaliation, no temporal sequence supporting motive. You can't claim retaliation when the enforcement action is the first contact. 6. Claim 4 flips due process on its head. Fredrickson argues, open quote, courts don't excuse constitutional violations based on form errors. Close quote. But what actually happened is, he deprived the court and defendants of proper notice, he used an address he could not be served at, he misrepresented occupancy, he then blamed others for investigating that misrepresentation. That's not a due process violation against him. That's procedural abuse by him. Bottom line, the address issue is material, not trivial. It explains Archbell's presence. It is corroborated by a neutral property owner. It aligns with zoning and enforcement records. It explains service failure documented by the court. It undercuts every claim of retaliation or pretext. Calling this utterly irrelevant isn't legal analysis, it's damage control.